Students, today we're going to be talking about due process. We're going to be talking about what occurs before, during, and after the trial. The first couple of slides here are going to be, hopefully, a reminder. They're going to be a review of what we went over with the Texas judiciary system. Please remember, civil law deals with private rights and relationships, obligations, responsibilities. These cases are brought by plaintiffs, usually private citizens or corporations, but it can be the government. The government can be the plaintiff in civil law. Remedy is relief from or compensation for the harm. So compensation, once again, was money. Relief from whoever is harming you, they stop whatever action it is to harm you. Turn the music down. Clean the site light. Do whatever it is that is harming you. The origination of civil law is based on common law. And common law is just defined as judge-made law or judge-made decisions based on precedent. What is precedent? Precedent is what came before. We see that judges rely on precedent, and we, the people, actually need precedent. Judges rely on precedent to guide them. They rely on the past to guide them in today's decision. We want to make sure everybody is being treated equally. Everybody is being treated the same. So the judges are going to look at past decisions and say, okay, these are my signposts. These are my guideposts. I'm going to rule the same way that they did. Now, there's another type of law out there called statutory law. Statutory law is simply law that has been passed by legislative bodies and is written in code books. This is also referred to as codified. C-O-D-I-F-I-E-D. So statutory law or codified law. Law that has been passed by legislative bodies and is written in code books. Once again, why do we need precedent, but why do we need statutory law? Why do we need this law written down? Well, imagine the police come in, look at you, and say, you're under arrest. And you're sitting there saying, wait, what did I do? And the police say, it is illegal to wear a pink shirt. Is it illegal to wear a pink shirt? I don't know. If it's written down, if it's codified, do we know if it's illegal to wear a pink shirt? Yes. So we need this codified law so we can actually see which of our actions are illegal. Is a statutory law or codified law a new idea? No, it's not. If we go back in time, if we look at the Code of Hammurabi, created 1780 BC. It's one of the earliest sets of laws found at one of the best preserved examples, So we see Hammurabi's code, we see codified or statutory law written in 1780 BC. This idea is about 3,800 years old. This is not a new idea. As a nation, as a state, we didn't make any great discovery. Types of civil law. I said earlier, or in the last section, that there are many different types of civil law in Texas. So we can see that civil law in Texas can deal with common law marriage. What do you need to be common law married? A lot of people have an idea, but let's look. No, not what I wanted to do. Let's look again. There we go. Section 2.401 of the Texas Family Code states that a common law marriage may be proved by evidence that the couple agreed to be married, and after the agreement they lived together in this state as husband and wife, and they represented to others that they were married. Guys, gals, everybody, students, this is it. There is no time frame, nothing like that. Told you needed to look through these laws to see what was going on, didn't I? Homestead laws. Protection of homestead from creditors, that kind of thing. Your tax reduction. Probate. Remember, probate was wills. Dealt with making sure a will was carried out as intended. Corporations, businesses, this is our business law. How to create a corporation, a limited liability corporation. Banking laws, all this kind of stuff is going to be in here. Right to work laws. Texas, we're a right to work state. You do not have to belong to a union to get a job. You don't have to give 2 weeks notice. Your employer can fire you for any reason other than the big four, than the federally protected race, religion, age, and gender. In the state of Texas, you can be fired for any other reason but those. Negligence. You should have known your action would cause harm. Any reasonable person would have known this action would have caused harm. Slander or libel. This is going to deal with saying disparaging things about others. This is going to list actual malice. Slander is spoken, libel is written. What we're talking about here is when somebody says, so slander, or writes, libel, something negative about you with the intent of hurting your character, with the intent of making you look bad. That is slander, that is libel. Guys, it's really hard to prove, especially in the media. If we're reporting a story, hey, so-and-so's been arrested, well, that's an actual story. That's not libel because it's true. They're just reporting a story. They're not doing it to harm you. Issues in civil law. I want to talk about tort reform. A tort is another name for a civil law case. In the early 2000s, the Texas court system, our civil law court system, was overwhelmed with cases. They couldn't keep up. So in an effort to reduce the number of lawsuits, of torts that were filed, the Texas legislature came up with 4 ideas for tort reforms. The first 2 can actually go together. Restricting lawsuits by prison inmates, reducing frivolous lawsuits. Now, guys, how would this lower the number of cases in civil court? Well, first off, what we have to realize is that some of the best legal minds in Texas are found in prison. Why? They have too much time on their hands, and they have access to law books. They have nothing else to do but read and learn and then sue the state. Now, here's the catch with a civil lawsuit. If you were sued, and I hope you never are, but if you were sued, you have a certain time frame to respond. If you do not respond, the plaintiff can go to the court and ask for a motion of summary judgment. They can say, hey, the defendant did not respond, I win automatically, and the court will grant it to them. The court will grant them to win. So if you are ever sued in civil law, you have to respond within the time frame. Well, it's the same thing with prisoners. They sit around and sue us, and it may be a silly suit, but we still have to respond. We still have to deny it. So think about how this cost us money. Almost everybody except prisoners, they have to pay a filing fee for a lawsuit. How come prisoners don't? They're not working. So the suit gets filed. It is heard in a court building, in a courtroom, which is paid for by you and me, the taxpayers. The court staff has to deal with it. They are paid by you and me, the taxpayers. The judge has to deal with it. The judge is paid by you and me, the taxpayers. We have to pay an attorney to respond to say, I deny this. That attorney is paid by you and me, the taxpayers. Then it's got to go in front of the judge again and take more time, where the judge has to dismiss the suit if it's frivolous, if it's not a real lawsuit. So this cost money, this cost time. So the legislature was trying to prevent the prisoners, the inmates, from filing these frivolous lawsuits. I mean, for a frivolous lawsuit, are all lawsuits filed by inmates frivolous? No, they're not. There are some legitimate lawsuits out there, but some of them, they are just done so that the inmates can do something. There was one lawsuit, the state of Texas got sued by an inmate, says that we violated his 8th Amendment right against cruel and unusual punishment. You know what we did to this inmate that violated his right against cruel and unusual punishment? Apparently, we fed this inmate peanut butter and jelly sandwiches for lunch 3 days in a row. And to him, this was a violation. This was cruel and unusual punishment. Does this sound like you growing up? For most of us, yeah, it was. Was this a frivolous lawsuit? Yes. Are inmates the only one who can file frivolous lawsuits? No. Oftentimes, individuals will file lawsuits as a means to harass their neighbors. There was a lawsuit a few years back. I remember seeing it. A young couple bought a house, they moved in, and a few months later, their neighbor, an older gentleman, sued them. It was like stress and anguish, something like that. And his story, he says, well, they don't have curtains up in their house. So every time I go up and I look in their windows, I see them walking around nude. Yes, you heard me right. His argument, his complaint was every time I go up and look in their windows, since they don't have curtains, I can see in, and they're walking around nude. Is that a frivolous lawsuit? Yes, that is. Are there more issues than that? Yes, but this is a frivolous lawsuit. Limiting liability in civil cases involving multiple defendants. What we are trying to do here is avoid people looking for what we call deep pockets. Deep pockets are people that have a lot of money. If you go to a mall, you slip and you fall, we don't want you suing everybody in the mall instead of the small shop that is responsible. If you sue, you're looking for deep pockets, the people that have a lot of money that are going to pay you to go away. So we're trying to limit liability in these cases. The last one is capping jury awards of punitive damages. Now, what is a punitive damage, or what are punitive damages? Punitive damages are added on top of the regular compensation, the regular award. This is a means to punish the company, or to punish the defendant for whatever actions they took. We came up with this idea, we being the state of Texas, came up with this idea in the early 2000s because Texas did not have enough doctors. We did not have enough medical practitioners. So we were trying to convince doctors to move to Texas and start their practice. Now, what is one of the biggest expenses that a doctor is going to face? It's malpractice insurance. If you know how insurance works, you know that you pay your premium. You pay X number of dollars. And in return, your insurance company will pay up out to a certain amount. You may pay $1,000 for a 6-month car policy, and your auto insurance will pay out up to $50,000. What if you want more than $50,000? Well, you pay in more. You pay in a higher premium. You pay in $2,000, and they'll cover up to $100,000. The premium amount that you're paying depends on the coverage amount that the maximum amount they may have to pay. So, how would capping punitive damages affect malpractice insurance? Well, if we look at the cap, what we see in Texas, punitive damages, they will only be awarded if other damages are also awarded. Punitive damages are capped in Texas as listed in the Texas statutes here. They are capped at the greater of $200,000 or 2 times the amount of economic damages plus the amount equal to non-economic damages up to $750,000. So basically this means that the most you will pay out is $750,000. Now, why is this important to your premium? Why is this important to an insurance company? With there being a cap in Texas of $750,000, the insurance company knows exactly the maximum amount it will have to pay out, and they can base their premium on that $750,000 figure. Now, what if you go to a state that doesn't have a capped amount? How much is the insurance company going to have to pay there? They don't know. $750,000, $1 million, $2 million, $5 million, $10 million, whatever. They don't know. So they have to base a premium on somewhat of a worst case scenario. So their premium's going to be higher because they can expect to pay out $5 million, $10 million. So this was a means, this capping the jury awards of punitive damages was a means to convince medical providers to come to Texas. Did it work? Actually, yeah, it did. We did see an influx of new doctors. Have the tort reforms worked? I've got an article in here that reviews it. But these are all civil law. Let's go ahead and go to criminal law. please remember, criminal law is concerned with public morality, concepts of right and wrong as defined by the government. How does the government define these concepts? How do they let us know what they consider to be right and wrong? They create laws. They create the penal code. Cases are prosecuted by public officials. Cases are prosecuting by prosecuting attorneys. In district court, it's going to be the district attorney. County court at law, it's going to be the county attorney. The aim of criminal law is punishment. Remember, under civil law, we were worried about responsibility, determining who was the most responsible. Under criminal law, if you have broken the law, if you have done something against public morality, we are going to punish you for your act. In the United States, we have two types of crime. The first, federal. What we see is only about 5% of crimes are prosecuted under federal law. Most of these are state crimes. Why is this? Well, remember, who does most of the governing? Who does most of the regulating? The states do. The states have a much larger impact on our everyday life than the federal government does. The state, well, we follow there's many more laws created by the state that we follow than created by the Fed. But, while I say the state does most of it, it is still possible to violate federal law. Commit a crime on the high seas. Commit a crime on federal property. Military base. Federal park. Post office. Bank. If it involves the crossing of state or national boundaries. If it interferes with interstate commerce. Committed against the national government. Treason, bribery, tax evasion. These are all crimes that would be considered committed against the national government. But this is a list of all crimes that would fall, or a number of crimes that would fall under federal jurisdiction, federal authority. So, of course, if there's two types of crime, one is federal, the other is state. So if we're talking about state crime, in Texas, the magic number is 2, we have two types of crimes. The first, the most serious, are felonies. Felonies are serious crimes such as murder or robbery. Now, we can subdivide our felonies. We have different subclassifications. The most serious felony is capital murder. Second one, first degree, then second degree felony, then third degree felony, then a state jail felony. The classification or the subclassification is important because this is going to dictate your possible sentence if you are found guilty. It's going to dictate your possible punishment. In Texas, we also have misdemeanors. These are lower level crimes such as traffic violation, driving while intoxicated, public lewdness, whatever. Once again, we can even subclassify our misdemeanors. Now, misdemeanors are less serious than felonies according to us, but they're still crimes. So for misdemeanor, most serious to least serious, Class A misdemeanor, Class B misdemeanor, then Class C misdemeanor. Once again, the type of misdemeanor is going to affect punishment. There is some discussion, are Are there victimless crimes? Prostitution, gambling, staying at home and partaking in illegal drugs. That's a conversation for a intro to criminal justice class. But there is an argument there are victimless crimes. Now, let's look at these. I told you that there's different classifications of crimes and they affected the possible punishment. Look at the top one, capital murder. This includes murder of a police officer, firefighter, prison guard, or a child younger than the age of 6, murder for hire, murder committed with certain other felonies, or mass murder. Terms. Possible punishment, right there. Execution or life sentence without parole. So life or death. Actually, I can't say life. It used to be life or death. Why did we change it from life to life without parole? There is a difference. In Texas, how do we rank in the use of the death penalty? Remember, we rank number 1. Well, we did some research to find out why juries were awarding the death penalty so often. And what we discovered was that the jurors said, we didn't want to sentence this person to death. We did not want them to die, but we did not want them to have a chance to get out of prison. You see, in the old days, life actually meant after 40 years, you were eligible for parole. So if you committed a capital murder at the age of 19, at the age of 59, you could actually get out. You could have actually have served your life sentence. People were so irate. We didn't want to give them the death penalty, but we didn't ever want them to have the possibility of being out. So we felt that we had to go with the death penalty. Well, once we discover this, the legislature changes the sentence from life to life without parole. Means they will never get out. We did this in an effort to reduce the number of death penalty sentences that were being handed out. Did it work? Yes, it did. We did see a reduction in the number of death penalty sentences. The maximum fine, we're not fining you because you're not getting out of prison, ever. First degree felony, 5 to 99 years, $10,000 fine. Second degree, 2 to 20, $10,000 fine. Third degree, 2 to 10 years, $10,000 fine. State jail felony, 180 days to 2 years, a $10,000 fine. Now notice in these first degree, second degree, third degree, and state jail, the fine's the same, but the punishment range differs. So the lesser degree felony, the less time, the less serious it is considered to be, the less time you will serve. Get down to our misdemeanors. Class A, up to 1 year in jail, up to a $4,000 fine. Class B, up to 180 days and a $2,000 fine. Then once again, Class C, no incarceration, up to a $500 fine. Have you ever seen something and said, there ought to be a law? We shouldn't do this. How does Texas compare when other states have decided there ought to be a law? Tennessee makes it illegal for anyone other than a zoo to import skunks. West Virginia makes it illegal to taunt someone fighting a duel. Texas makes it a crime to disturb someone who is hunting. Rhode Island requires that a driver must make a loud noise when passing on the left. North Carolina limits their bingo games to 5 hours. New Jersey and Texas make it illegal to wear a bulletproof vest while committing murder. I have no idea. Why does wearing a bulletproof vest while murdering somebody make it worse? I don't know. In Wisconsin, it is a crime for restaurants to serve margarine unless requested by the customer. These are just some of the laws out there. Some of them I think I could actually make an argument for. Some of them I just don't know. Anyway. The criminal. We see that there are similarities in those who commit crimes. Young, poor, racial or ethnic minority. What I don't have in here, but I'm going to ask you, is gender. Is there a similarity in gender of those who commit crimes? Yes, there is. Which gender most often commits crimes? It's male. So, when I say young, we're talking research shows males have usually outgrown their criminal tendencies by the ages of 23 to 25. So ladies, if you can get your man past that age, you're probably okay. They may have acute emotional problems. Now, this next one came out of a textbook. This was not my idea. Please don't get mad at me when I tell you this. But, did you know that criminals have little value for the law? I bet you couldn't have figured that out, right? Yeah, I know. Like I said, guys, please don't blame me. That came out of a textbook. One of the problems we have today is the increase in the divorce rate, the decrease of the nuclear family. We are seeing a number of kids grow up in single-parent homes, and often the single parent has to work multiple jobs to make ends meet. This parent is not home to provide the camaraderie, to provide the affection, the companionship that the young person needs. So instead, they go out and they look for this companionship somewhere else. Do they find it? Yes. Where? In gangs. We see that gang membership will provide the family ties that the young person is not receiving at home. I've included a link to the FBI crime statistics for a number of reasons. You can look over this. The victim. I need to fix that. Crime has declined since 1991. Overall, historical crime rates have declined. Now, be careful what this means. There was a debate when one candidate said the crime rate had gone down. One candidate said the homicide rate had gone up. Are they both true? Are they both false? Is one true? Is one false? They're actually both true. Yes, the homicide rate had gone up. The rate in one particular crime had gone up. However, the rates of other crimes had decreased. They had gone down, so when taken as a whole, the overall crime rate did decrease. We see the highest rates of victimization are going to occur in poor urban or in poor city areas. These are going to occur usually in neighborhoods against friends and family of the criminal. They don't have the means, the opportunity to leave their neighborhood to go find other victims. If you are the victim of a crime, you have the right to be informed of the investigation and court proceedings. Somebody from the police office, the sheriff's department, is supposed to keep you informed on the status of the investigation. If they make an arrest, if it goes to court, somebody from the judicial system, the court system, is supposed to contact you and let you know what's going on. They pled guilty. They pled not guilty. They're having court on this date. Whatever. You have the rights, as a victim, you have the right to be informed of what is going on. Law enforcement. The state legislature is in charge of defining crime. Once again, they do this by creating laws. The state legislature defines crime by creating laws. It is the state agencies and the local law officials, the police, the sheriff, the constable. These are the agencies that are responsible for enforcing state law. These are the ones that we're going to look to enforce the law saying you can't do this. Do they do a good job? Does law enforcement do a good job solving crimes? Well, yes and no. Murder, so if you're looking at homicide, there's an 80% chance that they're going to solve the crime. Rape, sexual assault, 44%. Robbery, 25%. Aggravated assault, 50%. Burglary is 10%. Larceny or theft is 17%. Motor vehicle theft is 13%. Arson is 16%. Are these numbers good? Murder, 80% clearance rate is good. Aggravated assault, sexual assault, 50%, 44%, not bad. But what I want you to look at is the top four. Murder, rape, robbery, aggravated assault. These have the top four clearance rates. The bottom four, burglary, larceny and theft, motor vehicle theft, or an arson, these are the bottom four. What's the difference between the top four and the bottom four? The top four crimes are actually crimes against people. They are crimes against individuals. Should we prioritize crimes against people over crimes against property? Most people would say yes, so we should see that higher clearance rate on crimes against people. Now, let's look at some of these agencies that enforce state law. First one, Department of Public Safety, DPS. They exist for a number of reasons. The first reason they exist, they're supposed to handle emergency management. If we have an emergency situation, we need to leave town quickly, they're supposed to help with the evacuation. Now, most of us are going to know the Department of Public Safety for this next reason. Conduct driver's examinations. So that's where we go to get our driver's license or to get our ID card. They also collect crime statistics. Each city, each county will take their information. They will send it to DPS. The Department of Public Safety logs it, and they send it on to the FBI to get those crime statistics I was talking about earlier. They will operate regional crime labs in areas that don't have one. And often, if we do enough driving, we see that DPS performs highway patrol in a number of rural areas. I've included a link to the DPS website. Go take a look around, see what they do. You may want to consider applying there. You never know. Now, the Texas Rangers are actually part of the Department of Public Safety. They fall under the authority of the jurisdiction of the Department of Public Safety. But I want to talk about one more, the Texas Alcoholic Beverage Commission, the TABC. They're there to make sure all alcohol laws are followed, that bars aren't over-serving people, they aren't serving the people underage, all this kind of stuff. But these are the two state agencies I want you to know. Local agencies. Local agencies, we're going to start with the sheriff. The sheriff's department, is the major enforcer of law in the county. Their jurisdiction, their authority, county-wide. The actual position of sheriff is an elected position. The sheriff is elected for a 4-year term. One of the main jobs of the sheriff and the sheriff department is to manage the county jail. What I mean by this is we have to manage the population. The jail, like everybody else, we have to be concerned with overpopulations due to physical dangers, overpopulation due to medical dangers. We have these occupancy issues. The sheriff is responsible for making sure that the jail does not go over the maximum number of occupants. The sheriff and the department execute court orders. This just simply means they serve warrants. Then they also apprehend violators of state law in the county. So that's in a nutshell what the sheriff's department does. Next one, constables. Constables are relatively minor county officials that are elected for a 4-year term. You see that the county is drawn up into precincts. Each justice of the peace has a precinct, or they're voted in to be the JP for that precinct. It's the same way for the constable. Each precinct elects their own constable. They are police officers. They take the same training. They take the same test. They do have law enforcement powers. Finally, we see city police. City police are said to bear the greatest burden. They deal with a local area that is usually more highly populated than the surrounding area, so that they're going to see more crimes. There are going to be more offenses. Law enforcement, overall, for our local government. Is it cheap or is it expensive? It is very, very expensive. We see that cities and counties can spend as much as 30% of their total budget simply for law enforcement. Detection of a crime. Many crimes go unreported, and we see that there really are 3 reasons why these crimes go unreported. The first, individuals believe the police won't, and we can say can't, assist when a crime is reported. What do I mean by won't, or if we substitute the word can't assist? Years ago, I was in grad school. I walked out one morning to discover the passenger window in my car had been broken in, and about $5 in change had been taken out of the center console. That was it. What was I going to call the police for? They couldn't trace the change. To repair the window was less than my deductible, so I didn't need a police report. All it would have been was a waste of time for them and for me. So sometimes it's not that they won't assist, it's they honestly can't assist. Second reason, mistrust of authorities. We're going to see this reason more in our big cities, our more diverse neighborhoods. If we have these immigrants who have come from countries where the police officers are corrupt, the whole system is corrupt, they are abused by the police officers, it would be normal for them to get here and believe that the police officers here are corrupt like the police officers back home. So they don't want to take a chance and they don't want to have any interaction with them. The last reason, we see an unwillingness to report a friend or a family member, a relative. Why would this prevent you from reporting? Let me ask you this. If you got home and discovered that your house had been broken into, how do you feel? You're mad. You feel violated. You're upset. A couple of days later, you discover it's a 15-year-old relative, cousin, nephew, whatever, something like that, that broke into your home and stole your property. Do you call the police? If you call the police, you're right. It is your right to do. They violated the law. But if you call the police on your relative, can you imagine what your next family get-together is going to be like? How much drama is there going to be? I would like to see that. But that's the third reason. Unwillingness to report a friend or a relative. Well, the crime was committed. The crime was reported. So now the local officers, or DPS, whoever, they have to gather evidence. The U.S. Constitution, the Fourth Amendment, there's a court case called Mapp versus Ohio. This prohibits unreasonable searches. This means that the police cannot come search your things just for fun. They must have a reason. They must have a warrant. Well, I say they must have a warrant. Is that true? No, warrants are not always required. Is it reasonable to search you without a warrant? Yes, it is. The police can make a reasonable decision to search you without a warrant. Well, who decides if it's reasonable or not? The police? They're always going to say it's reasonable, right? No. The reasonableness of a search is determined by the courts. They will say that they had something called probable cause. These magistrates, these judges will determine probable cause. If they say yes, you had probable cause, the search was reasonable, they will allow the evidence they gathered, or the items they gathered, into evidence. But if they say the search was unreasonable, then we see that illegally obtained evidence is not allowed in court. Confessions. We see illegally obtained confessions are unconstitutional. You cannot force somebody to confess. This comes from another Supreme Court case, Miranda versus Arizona. I've included the case brief so you can see what happened. But what we get from Miranda versus Arizona is something called the Miranda rights. The police have to tell you your Miranda rights when they arrest you. Now, how many of you have ever seen the Miranda rights read on TV? Maybe you've had them read to in person. I'm not judging. I don't know. But how do the Miranda rights go? Have the right to remain silent. Any statement made can be used against you. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. We know what these are. Okay, formal charges. In a felony, the case is bound over for a grand jury. Remember we talked about that grand jury, 12 people? The prosecuting attorney presents their evidence to the grand jury. If 9 of the 12 people on the grand jury agree that we need to hold a trial, we need to have further investigation, 9 of the 12, 75%. If they say yes, they will issue that indictment. There is sufficient evidence to believe a crime was committed. We need further investigation. Arrest. Arrest in itself is a form of punishment. I'm assuming when I get these that you are hearing the news story also, that you're getting the audio. Apparently I'm wrong. Hey guys, do me a favor. Please sit here and watch this video. Just watch the first half of it. It's talking about a prostitution sting, and one of the people arrested was a pastor at a church. We see this all the time. These stories. If you read your local newspaper, if you go to their website, they'll often have links that X number of people were arrested for prostitution and solicitation of prostitution. 33 people were arrested in whatever city last month for felony DWI. And they include their mugshots, their name and their mugshots. Why would this be considered a form of punishment? You're accused of a crime. That's just it. You are accused of a crime. Have you been found guilty? No, you haven't been. I mean, imagine that if you are arrested for solicitation of prostitution. Call your boss and say, I was arrested, that's why I missed work today, but I'm not guilty. Call your significant other and say, honey, the reason I didn't come home last night, wrong place, wrong time, I was arrested for solicitation of prostitution, but I'm not guilty. Call your mother. Explain this to her. Is this embarrassment? Is this humiliation? Yeah, this is public embarrassment. Everybody knows that you were arrested. Not convicted, but you were charged. You might not have done it. So, we see that magistrates, judges will issue an arrest warrant. Arrest warrants are like search warrants. Police officers may arrest without a warrant if there is probable cause and circumstances do not permit their obtaining one. Now, probable cause, an officer believes a crime has taken place or is getting ready to take place. So, for example, 2 o'clock in the morning, an officer sees a car weaving back and forth again, across the lanes. They can't maintain a single speed. They speed up, they slow down. Do they have reasonable cause to stop this car? Yes, because of driving while intoxicated. The police have a reasonable suspicion that a law is being broken, that the person is driving while intoxicated, so they can stop it. They do not have time to go get a warrant, because what if they leave? Well, where's that car going to be an hour later when they get the warrant? Who knows? Hopefully home, and you're safe in bed if you're the driver. But you don't know. You didn't have time. Pretrial activities. The accused. It's you in the orange suit there. You're presented before a magistrate. You're presented before a judge. Charges and basic rights are explained. You're reminded of your rights. You're told that you have the right to an examining trial. You have the right to a trial by judge or by jury. You do not have to plead guilty. You may receive bail. Bail may be set. Bail simply, you pay X number of dollars, they let you out, you promise to return for your court date. This stuff is really, really simple. Pre-trial hearings. The defendant enters a plea. If the plea is guilty, a later hearing is scheduled to set punishment. If the defendant pleads not guilty, we're going to see the case is placed on the court docket for trial. The court docket is simply the court calendar. You're going to be placed on the court calendar for trial 2, maybe 3 months later. Now, while you are waiting for your trial date to come, does this mean no work is being done on your case? No, it doesn't. What we see, that while you're waiting for this trial date, that motions may be presented. Case motions may be presented by both the plaintiff and the defendant. Some of these motions, a motion for continuance. You're just asking that the date be moved back a little bit. You know, perhaps one of the attorneys has taken on another case. Perhaps you haven't gotten test results back. You haven't been able to talk to all the witnesses. So all you're going to ask is, you know, instead of starting the trial on November 14th, could we start it on November 28th? We're asking for a continuance. That's all. A motion to suppress. The motion to suppress certain evidence. You're telling the court, hey, this motion was gotten illegally. It should not be allowed into trial as evidence. Possible insanity. They are not altogether there. They did not know right from wrong, or they are insane. They cannot aid the attorney in their own defense. We need to get them a mental evaluation. Last one, change of venue. Change of venue. What we see, crimes are tried in the county that the crime is committed in. Well, what happens if we have a heinous, a horrible crime that got a lot of media attention? Well, we may ask for a change of venue because we are concerned with the defendant getting a fair trial. If there has been a lot of media coverage, a lot of media saturation, do you think that the jury pool, are they going to be biased or are they going to be open? Chances are the jury pool's already seen something on the news about this case and they are predisposed one way or the other. So we ask for a change of venue. We may move a couple of counties over where hopefully there hasn't been as much media coverage. Hopefully that the defendant will be able to get a fair trial. Plea bargaining. What we actually see, most cases end in a plea bargain. Plea bargain, somewhat secret bargaining session with the prosecutor. The prosecuting attorney, the defense attorney will get together, and the defense attorney will come up and say, the prosecuting attorney's made you an offer. If you plead guilty to DWI, you'll get 12 months probation. If you plead guilty to DWI, you could serve up to 6 months in jail. You'll serve 3 days in jail. If you've been charged with DWI, if you plead guilty, they'll reduce the charge to reckless driving. There is some sort of offer. The prosecuting attorney is attempting to give you some sort of incentive to plead guilty. We like plea bargains. It saves tax money and court time. Most people will take the plea bargain, so we don't have to have a trial. There's an article, pros and cons. Read it at your leisure. Now, if you don't accept the plea bargain, you go to trial. Either the judge or the jury will determine the verdict. It is your choice. You have a right to a trial by judge. You have a right to a trial by jury. The judge will determine the verdict, guilt or innocent, if the jury trial is waived. If you choose a jury trial, Texas law requires all jurors to agree on the verdict in a criminal case. This means they have to all agree guilty. They have to all agree not guilty. Once all of them agree, this is when the case ends. They find you guilty. Yes, the prosecutor proved their case. They find you not guilty. They acquitted you is the correct term. You were acquitted. The prosecutor didn't prove their case. Please remember, the prosecutor must prove guilt beyond a reasonable doubt. A hung jury exists when jurors cannot agree. When we can't get that unanimous decision one way or the other for guilt or for acquittal, comes back as a hung jury. This can be good, this can be bad. This is good because you as the defendant, you weren't found guilty. You're not going to be incarcerated. This can be bad for you, the defendant, because the jury did not deliver a verdict. If the prosecutor wants, they can try you again. You may have to go through another trial. If the jury agrees you are guilty, unanimous decision, the judge or the jury can decide the sentence. Post-trial, after the jury decision. If you have been acquitted, if the jury comes back and says the prosecutors didn't prove their case, you are free to go. The prosecutor cannot try you again for the same offense. This is called double jeopardy. Double jeopardy, you cannot be tried twice for the same crime in the same court system. So if the prosecutors don't get it right the first time, they cannot come back and try you again. Which means that if you get a not guilty verdict, if you are acquitted, the state can't appeal. Once you get that acquitted verdict, that not guilty verdict, you are free to go and the state can't do anything else. It's over. Now, I do want to talk about juvenile courts for a second, and I mentioned in the last section, I would talk about juvenile and criminal cases and stuff later on. What we see most juvenile proceedings, even for criminal activities, even for criminal laws, are tried in civil court. Why? Couple of reasons. The first, if it is tried in civil court, any records from the court proceedings may be sealed from the public with the approval of the juvenile judge, which means who can see them? Nobody. They are sealed away. Now, the second reason in Texas we do this is, how old do you have to be in Texas? What's the age of adulthood in Texas? 17. Once you hit 17, you're an adult. We feel that before the age of 17, you are young and dumb. You're going to make mistakes. You don't know better. Well, what happens at the age of 17 and you make that felony mistake? You are convicted. You are now a felon. How long you were a felon for? For the rest of your life. That title is going to follow you around for the rest of your life. What does that do to your life? It makes it extremely difficult. You can't get certain jobs. You can't qualify for certain government programs. You're going to have a hard time earning a place to live. It just makes life extremely difficult. Well, for juveniles, because the state of Texas feels like they're young and dumb, if we try them in civil court, even if we find them guilty, then they are not convicted in criminal court. They are not felons. They do not have that felon tag that's going to follow them around, making life more difficult for them. Does this mean we try every juvenile in civil court? No, we don't. We do try some juveniles in criminal court. It's going to be up to the prosecutor. And actually, and I said a minute ago, the age of adulthood in Texas is 17, but we do see in Texas that some juveniles we can certify to stand trial as an adult. Children as young as the age of 14 may be certified to stand trial as an adult. There's an op-ed about changing the age of juvenile courts from 17 to 18. I just threw that in there in case you're interested. Let's talk about the Texas Department of Criminal Justice. They supervise the state's adult correctional functions. Supervise the state's adult correctional functions. So there's 3 items we're talking about. The first, probation, correct term, community supervision. This is pre-incarceration. Instead of locking you up, we're letting you out, or you're staying at home, but you still belong to the state. You're still under the supervision of the state. You're going to go meet with your probation officer once, maybe twice a month. You're going to have conditions you have to follow, fines, fees, possibly restitution, community service. Travel can be restricted. You may have to take treatment classes, this kind of thing. But this would be probation, but you are not being incarcerated. Prison, you're incarcerated. You're going to go spend 10 years as a guest of the state, locked up in a state prison somewhere. The last one, parole. Parole is after incarceration. You have been locked up, but you've been a good prisoner. You haven't been in any trouble, so we're going to let you out of prison early. You still belong to the state. You're still serving a sentence, but you're now free to go home. Much like supervision or probation. You're going to have conditions. You're going to have to meet with a parole officer. Travel is going to be restricted. All this kind of thing. But these are the three things that the Texas Department of Criminal Justice oversees. Clemency. Board of Pardons and Paroles makes recommendations to the governor. Guys, we've already talked about this once. Hopefully you got that video, you watched it. It's going to make recommendations to the governor regarding pardons, commutations, reprieves. The last thing I want to talk about in this section, jails or prisons. What is the proper use of a jail or prison? What is the proper use for incarceration? There's an argument that there are four proper uses. The first, punishment. You broke the law, you must be punished for your actions. The second is deterrence. The idea behind deterrence is if you know you can be punished for this action, you won't perform the action. That's deterrence. Third, isolation of criminal elements. You are so horrible, you are so bad, we can't put you with anybody else. You can't be with normal people. The last, rehabilitation. Yes, you made some mistakes, but we can rehabilitate you. We can make you a productive member of society. Is any one of these reasons better than the other? No. These, like I said, all four of these are considered proper. If you believe one is more important than the other, that's just a personal belief.